We got another executive order with regards to the birthright citizenship. On the face, it says this is to avoid the uh, birth tourism, where people come on a visiting visa only for the purpose of giving the birth. Though, however, when you look into the executive order, it definitely details that even people coming on H visas, L visas, F visas, if their intention is to give birth to the children, they may restrict these people coming into United States. Now, to my understanding, I have a mother. Every of you guys, every person who's listening into this one have a mother, and their tendencies, the ladies, the woman's tendency is, and when they're of that particular age, they do give birth. That's natural tendency. So how are they going to restrict? Are they telling that no ladies of birth, those people who are, of the age from anywhere between 18 years to 50 years age are not allowed to come into United States? Or how are they going to determine that a particular lady is not never going to give a birth in United States?
Well, their plan is to not provide a passport to the child that's actually born with a list of things that their parents may or may have not done. So if either parent is not a US citizen and they are, employed by a foreign embassy, they're employed by an international organization, they're ambassadors, they're a person that is an alien enemy. But the one that is scary is if either parent of that person engaged in a commercial transaction to purchase or access birthright citizenship for the person, or engaged in a commercial transaction to ensure that the person's mother is present in the United States to give birth. So if I am an H4 holder and I am outside the country and I buy a plane ticket to the United States, that of course would be a commercial transaction. If I later give birth to a child in the US, are they going to claim that I engaged in a commercial transaction to ensure that I was present in the US to give birth? I mean, that's what the ridiculousness is here, but I do think that's what they think they have the power to do. Stephen, do you think they actually have the power to do this? Has got any leg to stand on?
I don't think it does. I mean, there are enumerated grounds that are in regulation. Now it is a regulation, so Department of State can change it as to why Department of State can not issue a passport to United States citizens. It's, outstanding child support, tax debts, certain criminal matters, stuff like that, right? Like things that would make sense, not providing a passport. None of it is your parents may have had a commercial transaction. Now, this one's a little bit different because it's not saying you're not a citizen. This isn't really, it's a 14th Amendment issue in that it's a due process issue, but it's not saying you're not a citizen. It's just saying we're not going to give you citizenship documents, the passport. If the administration wants to crack down on what they view as birth tourism, that's their prerogative. They did it in the first Trump administration, right? Like it's been in the Foreign Affairs Manual. I don't think you can deny passports, even if, okay, we've engaged in birth tourism, which may or may not even be legal, okay? That still doesn't prevent the fact that they're a citizen, right? And so you can't issue it. And so, again, I don't think I think this is a election year executive order, right? We've got to try to get the base excited, and it's the dang leftist judges that are doing it, not, the Constitution.
I think so. This executive order is also to frighten the foreign community, the people who are legitimately living in United States, though. Have you seen there is nothing about undocumented aliens in this particular thing? It's mostly about legally present in this country only.
Mhm.
Not much is written about that. And I believe that until this has been thrown out by the courts, which I think so pretty soon it's going to be thrown out in the courts, they are going to use it to restrict people coming into United States. So right now, if there is any child, anybody who is 18 years old to 50-year-old woman who wants to travel, even on a H4 visa, H1 visa outside the country, L1, L2 visa, going outside the country and coming back into the country, may get extra screening for it, though. Now, I have seen people who are a B2, B1, B2 visa getting screened. I had no issues with it because if they are coming here to give a birth, it makes sense for them to not allow them to come into the United States. But what if a lady is pregnant and she is traveling and she's 3 months pregnant or 4 months pregnant, she's traveling to her home country. Let's say she's going to Canada and she's trying to come back on a TN visa. Would that be a problem? Could be a problem. Even though the H1 and H4 are a dual intent visa, H1, H4, L1, L2 are dual intent visas. Now, that has nothing to do with the child birth. So they may still face a problem too if they're traveling outside the country. So until the things are a little bit more clear, I do not want the people who are already here in United States, women who are between 18 and 50, should not travel outside the country and come back, and they should stay in the country. Now, those people who are outside the country, who are the non-immigrant visa holders, now I'm not speaking of B1, B2 visa people, particularly I'm speaking about F1, F2, or because these are the long-term staying people. And H1, H4, L1, L2, if they're coming into United States, even if you are not pregnant at this point of time, I definitely want you to be very cautious to provide all the documentation necessary and face them at the point of the CBP. Now, do they have to answer? I never intend to give any birth to anybody, Emily. I mean, that's against the nature, is what I'm thinking of women.
Right. Yeah. I mean, I think I would argue that the executive order talks about engaging in a commercial transaction to ensure that the person's mother is present in the US. So if you are not pregnant yet, how could you have engaged in that commercial transaction to ensure that you're present in the US specifically for that purpose? I think that if you have another valid, legitimate purpose of coming into the US, then you should be fine. The problem is we're not dealing with rational, reasonable people that follow the Constitution. We're dealing with people that are looking for any reason to deny entry. And the other issue is it's going to take how long? Potentially a year before courts block this. I think we'd probably get an injunction rather quickly, but is it going to go all the way up to the Supreme Court again? That took a year and a half for the last one. So everything is in limbo up until that point.
Yeah, Emily, I tend to agree with you. I'm not, when I first read this, and look, I will always err to the side of caution. So I'm not going to say Rahul's wrong. But I think, again, a strict reading of this is to ensure that the mother's pregnant. So maybe if you are already pregnant and you're like, okay, I got to make sure I'm going to have birth in the United States, maybe then they could stop you. But I think if you're going about your day, or even if you're pregnant, hey, I got to come back to work. I think that's a little different. So maybe if you're pregnant, you have a little bit of caution. I will say, every time my wife's been pregnant, her doctors have always cautioned her about airline travel anyway. But again, to your point, Emily, I'm going to use my favorite word here. We've got a bunch of jabronis at ICE and CBP who are finally given authority, that they can go out there and flex their muscles and make people's lives miserable. So what do we see come from this? But again, until we see anything that says we're going to ban people at airports, I don't know. This is more about, we're not going to issue you a passport if your parents did one of these things.
But how, I mean, right now, when you submit the passport, all we do is that You just submit the birth certificate and get the passport. The only thing that is required is, I mean, if there is a issue between wife and husband, there is a custody issue, they don't give the passport, which is reasonable. That's fine. That's absolutely legal way to do it. But right now, if the mother and father are, on the same agreement, which 99% of them are, and all they do is that mother and father signs off and the kid gets a birth certificate. Now, what do we have to submit right now? When you say, what do you mean commercial activity? You're saying buying a ticket is a commercial activity? What about she's eating a chocolate?
I mean,
what about a banana? I mean, that's a commercial
I,
activity. She went to Kroger and bought a banana.
I will go back to what I said at the beginning. I just looked, 88 days from midterm elections. I think this is political theater, right? We got to rile up the base, make everybody happy. We're doing what we can, and we need to keep, power so we can continue to do all these things. I don't even know how this is enforceable, the way it's written.
Yeah. How do you, as an applicant for a passport, I'm submitting my child's passport application, how do you prove a negative that you did not engage in a commercial transaction to ensure that the mother was present in the US for the birth? I guess you submit your plane ticket showing you came before you were pregnant. I don't know what else it would be. It's ridiculous.
Yeah, and then what's the standard, right? You are pregnant, you travel, you went on a cruise, let's say, we were taking a vacation. So now do you submit a statement saying, oh, I was just on vacation or I was traveling for work? It wasn't about the pregnancy. What's the standard of proof there? And I'm sure we'll see policy memos in the next couple of weeks come out from Department of State and CBP and all that on how they're going to interpret this. But I don't even know that if we say that this is legal, let's just say that it's constitutional. I don't know how you enforce this executive order other than election day is 88 days away.
I think so. This is more about a political stunt, actually, rather than this is a political stunt rather than actually a policy which is going to stand there, Emily. That's what I'm thinking. Only until this election, and after this, they know that this is going to be lost in. This is going to be lost in. This is going to be lost in the court. That is fair. But right now, in the interim period, we may see some port of entry issues, is what I'm thinking about, and maybe some visa denials. But I'll be very surprised if the passport will be denied, because that's people aren't going to go there. Nobody's going to wait there. They're going to go to court, and the court may be contempt of court too. I don't know.
We go look back at the Supreme Court decision in Trump v. Barbara. Alito talked a little bit in his dissent about birth tourism. But if you go back and listen to the arguments, and the Solicitor General was talking about birth tourism, and it's a new world. It's a new world. We never had this. And the Chief Justice Roberts, it's the same Constitution. If they want to put things in place that restrict, and again, they've had it in the Foreign Affairs Manual before, and so there isn't a constitutional aspect of it. We can talk policy about birth tourism, but constitutionally, it's very different.
Yeah, I mean, if your real issue is birth tourism, you don't solve that by not giving the child a U.S. passport or denying them citizenship. You solve that by not letting them into the country or not giving them a visa when it's clear that they're coming into the U.S. for birth tourism. And you have to enforce that.
And we've seen investigations and all that into these supposed, birth tourism businesses, it's what I'll call them, that they're investigating, and maybe there's criminal charges there, but that is within the administration's power.
Yeah,
to crack
they should
down
do it.
on.
They should do it.
Not
the person who's going to work for a company. They are going to work for Apple or whatever companies they work for.
I agree. I just, again, I think you're right, Rahul. It's a political stunt. Shocking.
But please keep updated right now. This memo just came in. We have weekly Tuesday live sessions from 5 p.m. to 6 p.m. Central Time every week. For all the changes, what is going on, though, we do give updates, though. So it's not like where we can give all the information at one go. We don't know. These are developing things that will happen. And we are practicing lawyers. We are not YouTubers. We don't make any money. No money comes from us from the YouTube. For us, nobody pays us to do the YouTube. We are practitioners. We do our immigration practice, and we come across all these cases. When something come across it, we will update the information. We want you to subscribe and like our channel so that anything that comes out, you should. We also want you to subscribe to our blog at rnlawgroup.com so that new developments that are affecting, we only address legal people in United States and non-immigrant visa people, green card holders are our targeted audiences. But you need to be aware of what's going on and the developments that are going on. Right now, at this point of time, we are only thinking of traveling outside the country. May be a little bit dangerous for the people, especially the ladies, of course. And maybe if anybody is pregnant and traveling, wanting to come into United States, we may want them to speak with an immigration lawyer before you enter into the country. We want the people of childbearing age coming into the country, if they are not pregnant, to be very, be careful on what exactly you speak. That's all at this point of time, as far as my updates are concerned. But we'll keep on updating. Emily, what do you say?
Yeah, I think we just have to see how this is going to play out. Certainly it's going to be in the courts probably pretty quickly, and we'll take it from there. So take this all with a grain of salt that this does appear to just be for politics and for election year and for fear. And so try not to let it, discourage you in any way from doing what you would normally do, but just tread carefully.
We always have something not good thing coming up from the immigration. Thanks to Trump administration. We are discussing about a policy alert where the USCIS reasserted that they can deny the applications without issuing an RFE if the basic documentation is not there. Emily, this was the policy before in the Trump administration. Is it right, Stephen and Emily? What's the new alert about?
Yeah, so it was previously the policy during the prior Trump administration that they came up with a list of required initial evidence for every type of application, and it's posted on their website with each form. And if you submitted an application or petition without one of those required pieces of initial evidence, or if the documents you submitted showed that you clearly there's no way you could possibly qualify for the benefit you're applying for, they could just deny it flat out, take your money, deny it, and not issue a refund and not issue an RFE for an opportunity to correct it. That did go away during the Biden administration, and now they have resurrected it. And it applies to anything that's already filed or pending, anything that's filed going forward. The good news is, Stephen, did you ever see anything get denied in the prior Trump administration under the same policy, at least from an employment-based immigration standpoint with people using lawyers?
I don't think I ever saw us even have a consultation on it, let alone one of our cases or somebody saying they received one. It's not, I don't think I ever heard it in like the listservs or anything either, on employment based. There might have been some on like the humanitarian, asylum and stuff like that, but employment based, I didn't hear anything. And I feel like we had a pretty wide net of people.
They may use this one for some of the, if they use for some of the cases, Emily, I like those things. For example, if somebody doesn't have a green card and they file for the citizenship application, let me try it. Maybe I'll get it. Then they don't have to issue an RFE when they don't give the
So Rahul,
card.
you're not going to file my P1 visa for me to go play for the Astros? I'm qualified for. I just clearly don't qualify.
At least you must have played to some level of baseball, other than
or you
that
have
you
to be
played in the kindergarten. Huh?
That would help. That would help.
You played in kindergarten, you don't have anything there. Definitely, people feel fine. Yeah, he played in kindergarten. Now he's a very good baseball player. Then they could deny it. But mostly, they have used the intended purpose was to use for the kind of applications where they don't have any political asylum claim, but they fake it. Those kind of things, and probably somebody doesn't have a green card, and hey, I'm going to file for the citizenship anyway. Let me see it. Maybe they'll approve it. But this administration, when they issued the policy alert right now, though, I want to take it very seriously because I do think so that they will deny some applications, even though they have not done it. Even though, Stephen, you said you did not get any consultations on that thing, though, but I fear that this time they are very serious now. If we don't meet the fundamental requirements of the particular case, though, they may deny the entire application. And Stephen and Emily, can you tell, for example, if you're filing for a H-1B, what is the basic information required? Because they said if something basic information is not required, they will deny it.
Yeah, I mean, I think that they have listed, you need documentation of an LCA. That's going to be one of the required documents for an H-1B. Documentation that the position qualifies as a specialty occupation, documentation of how the employee qualifies for the position, documentation that there's a bona fide specialty occupation position available. So typically that's going to be an offer letter or contract. And then if you're requesting an extension, I think they typically want to see recent pay statements. In the previous administration, the initial required evidence also included a W-2 as an example. I haven't looked recently to see if that is still there. But basically, they do spell out on the website what is required initial evidence. And if you are filing something without one of those, you're at risk of potentially getting a straight denial.
Yeah, I mean, look, let's just use an example here. I mean, this right here, Emily, these are the forms. These are the I-129 forms right here. This is all the evidence we're submitting, right? If you submitted just these, 19 pages or whatever it is, 14 pages, you might get a denial without an RFE. But if we're not talking about your case has to be 100% perfect, I think they're still going to submit RFEs. It's just I'll give a good example, Emily. We have seen there are LCAs on social media where people talk about cashiers and, truck drivers. I think those were entered incorrectly, but let's say someone tries to file an H-1B petition for a cashier at a convenience store. I'm okay with USCIS denying it because you cannot qualify that as a specialty occupation. I know that this administration is starting from a position of no, but I mean, I texted with a client yesterday. I'm not panicked about this for the vast majority of the cases we do. And even people who don't work with attorneys do, because they are submitting those documents. But to your point, USCIS gives you the answers to the test on the website.
Yeah. And I will say, I have seen companies file things on their own without an attorney, and especially for an H-1B, not know that an LCA was required. And so all they did was file the forms. That does happen. And so it would be flat out denied in this situation. It would have been denied after an RFE anyways, because the company didn't even know an LCA was, so they didn't submit one, and you can't go back and get one after the fact. So I think that is likely still going to happen, but for the vast majority of people, that's not really how cases are filed. They're typically are filed with an attorney or with someone who knows what they're doing and follows the basics of what needs to be included. So I agree with you that this probably isn't going to be an issue for most people. One of the areas that I am concerned about is the timing of RFE responses. So they do specify that going forward, they're kind of going to leave it up to the officer how long they're going to give to respond. and that the maximum they can give is 12 weeks, but they're not required to give 12 weeks, which up until this point, it was policy to give 12 weeks on an RFE and then on a notice of intent to deny 30 days. We have been seeing some simple RFEs like asking for medicals and things like that. For a 485, often only give 30 days because those generally can be responded to pretty quickly and easily. But I still expect most will get the 12 weeks unless they're just trying to, I don't know, use this as a way to deny more applications.
That's like we just had a good question on YouTube. Do you think we'll still see like the biometrics RFEs if there's any sort of previous interaction with law enforcement, or do you think it'll get a straight denial? I still think we are. I mean, the reason they're sending you to biometrics is to confirm the identity. You might not know it, but there's a lot of Stephen Browns in the world. They want to confirm the identity, and that's why they do the fingerprint. So I don't think you're going to. I don't think not supplying evidence for them to exercise discretion, which is what that's getting at, is going to lead to a denial without an RFE.
So I'm particularly concerned, Emily, is that when we are submitting the H-1B, though, so if we don't submit the written contract between employer and the beneficiary or the terms of the contract, that may be an issue. Of course, labor condition has always been a cause for denial. Evidence that he's qualified for the beneficiary is always a reason for that. So basically, most of the things are definitely there that most of the lawyers will submit, though. But what about, he doesn't say that if somebody has an arrest record, we don't have to, I mean, it doesn't list as the necessary document to submit that one, is right? So
Right.
let's say they don't submit that one, will we get a denial?
I don't
Because
think
it's-
so. I think, to me, the policy is quite clear that they're talking about required initial evidence. And that means it's on that list. Like, again, every single form has what's called a checklist of required initial evidence. So I'm looking specifically at the one for H-1B specialty occupation. And it is evidence the beneficiary maintained status if they're filing for a change of status or an extension, evidence that the position qualifies as a specialty occupation, evidence the beneficiary is qualified, copy of any license that might be required to perform the occupation, written contract, and evidence of the LCA. Now, if you don't submit an education evaluation that goes along with the evidence of how they're qualified, or you don't submit arrest records for a person who's been previously arrested or has any kind of law enforcement interaction, I don't think they're going to flat out deny those. I do think that we will still get RFEs for those types of things because it's not listed as a piece of required initial evidence for that particular form.
I think, to your point, Emily, I mean, this is all couched in the belief that there are frivolous filings out there, and there might be in other categories. I don't think there's a lot of frivolous employment-based filings. And it does cause backlog with the agency when they have to allocate resources. And so, assuming we don't see some unprecedented level of attack, I don't think this, again, moves the needle for me all that much. Other than let's make sure we're submitting what we always do submit.
So right now, what I take the advice from Emily and Stephen is that it doesn't look to be serious for the normal people who are filing the employment-based immigration, non-immigrant visas and immigration. It may be serious for people who are really filing in frivolous applications, but for the normal people, the 99% of the people that we see, not only at we see as clients, but also we see in the immigrant communities, though, that are filing the application should not worry about it. Is that what I would take at this point of time? But of course, as the things will develop, though, you guys can change your ideas and say, no, right now, if there is a single document that is just slightly not visible clearly, maybe they will deny. We are not at that stage at this point of time. Okay. But if there is anything, you guys are going to update it.
Yeah, definitely. But good question here on YouTube. Does the regulation or statute allow them to do this? I actually looked into it because I was kind of curious. The statute's silent. They do have regulations to support this position. I think there's a little bit of an APA and due process issue, to be honest with you, to the extent there are these denials. But I never had to dig too much into it. But I think you certainly could.
Uh, what about the when we get an arrest documents at this point of time? You don't think so for, especially for the H1Bs and L1s, we don't need to submit it, is that right, Emily?
Right. Yeah. I mean, even for a 485, it is not listed on the. Well, I take that back. For a 485 checklist of required initial evidence for employment-based 485 applicants, it does include certified police and
Certified
court
copies.
records.
Right.
Yep.
But for H1Bs,
As
it's
well
not
as
listed.
the supplement J for those that require it.
Right. For NIWs and EB1As, they may not require it. For the rest of the people, 485J supplement is a required document. Medical is a required document. Birth certificate is a required document. When you don't have a birth certificate, there are alternative things that you need to submit. Those are the things you are required. Yeah, they may, but they may deny. They may deny if you don't submit these applications. But in general, I have seen them as of now, when the certified copies are not there, they were issuing an RFE assembly. So let's say somebody doesn't have a certified copies and they have to take a long time to get the certified copies. Do you think so right now they're going to deny because they listed them that they need the certified copies? And
I
some
think
of the counties don't even give the certified copies. There are 1,000 counties. Each county has their own rule. And some of them are expunged. How are we going to get the certified documents from them?
Yeah, I think that if a document is listed, you should submit something. It may not be the exact correct document. Like for your birth certificate, maybe you don't have it at this moment, but you probably could provide church or school records or an affidavit or something. You're attempting to provide something. They will then look at that, say, no, this is not sufficient, which is different from saying you didn't submit anything. So submit what you have and then let them send an RFE for the correct document versus if you don't submit anything, I think that's where you're at risk of a potential denial under this policy. But still, we haven't seen it a lot. Haven't seen any really in the employment-based categories yet, even during the previous Trump administration.
YouTube had a question I saw a lot pop up in the last couple of days. Emily and Rahul, what about medical submitted 3 years back that expired now? I still don't think you're going to see a denial. You were following the policy then, or now they've expired. I think you're totally fine. You're going to get the RFE. I don't think it's going to be a problem.
I don't think so. They'll get it denied.
But I've had that question pop up quite a bit this week. Obviously now, you have to submit your medical with the 485. So if you don't submit it, yeah, they could deny it without an RFE. But I think, like, let's say this, Ellie, let's say you have a medical. I've had cases where the doctor didn't sign it. I don't think that's going to get denied. I think you'll get an RFE. I don't, again, there is still an inherent level of process here.
Yeah, there's a difference between not submitting a document and submitting a document that they decide is not sufficient. And I think if you do try to submit something and they say it doesn't qualify, you should get an RFE with the opportunity to correct that versus not submitting anything at all. That's where you're at the greatest risk of one of these potential denials.
Does this policy alert is applicable to the pending cases, or it's only for the future questions? This is a question that Kushal Shah 7024 from YouTube asked this question. This is applicable for not only the future cases, but also already filed cases also. Think else, somebody?
think that's everything. Again, try to stay calm with all of these different announcements. Come to the actual source of practicing attorneys that can guide you on how seriously to take them, whether it's something to be overly concerned about versus, social media influencers and that sort of thing that are just looking for headlines and clicks. We'll do our best to provide you the calm, measured response so that you can make informed decisions and know how to move forward in your own case.
Nope, no issues. Everyone's got.
Thank you.
Everyone's